For the first time in Uganda's legal history, all the justices, the 9 who had the 2016 presidential election petition, gave a unanimous ruling.
We hereby declare that the first respondent was validly elected as president in accordance with Article 104 of the Constitution and Section 59 of the Presidential Elections Act. Accordingly, this petition is dismissed. We make no orders to post.
The justices are expected to give the details of their decision in 90 days. The petitioner, former presidential candidate Amama Mbabazi, had, through his lawyers, asked the highest court in the land to annul the election and order recount in 45 districts, including Kampala City, Wakiso, Chiruhura, and Rukunjiri districts, which they argued would expose the effect of vote rigging. But court was not convinced.
Counsel for the petitioner did not lay any ground for the prayer for recount in the 45 districts. We have perused and analyzed the evidence on record and are of the view that it was not necessary to order a recount as prayed.
Mbabazi, a former Prime Minister and close ally of President Museveni, also claimed that the Electoral Commission chairperson, Dr. Badru Chigundu, relied on what he called cooked results and not the declaration of results forms to declare Museveni as duly elected. But the justices found that the irregularity was not substantial. Although the petitioner lost on many of the grounds, he made some gains. The Electoral Commission came under fire from the court for delays in delivering voting material in some areas, with the worst cases being in Kampala City and Wakiso districts, which are not far from the Electoral Commission warehouses.
That the second respondent did not comply with its duty under Section 28 of the Presidential Elections Act. The failure to deliver polling materials to polling stations within such a close proximity to the Commission was evidence of incompetence and gross inefficiency by the Electoral Body.
Police also got some flak for blocking Mbabazi's consultative meetings in Soroti and Jinja districts in preparation of his presidential bid in September last year. Mbabazi also asks the court to inquire into why over 1,000 polling stations did not have their results declared to the Commission by 20th February, when the final results were declared. Court agreed with him. The Constitution provides that non-compliance with the relevant electoral laws in a presidential election should have a substantial effect on the results. In this case, court found that the inadequacies by the Electoral Commission were not substantial to warrant a cancellation of the results and a re-election ordered. Court exonerated President Museveni, who was the first respondent in the petition, all allegations against him. For instance, Mbabazi claimed that while campaigning in West Nile, Museveni violated Section 64 of the Presidential Elections Act by bribing voters with hoes as a sweetener to re-elect him. Court agreed with Museveni's legal team, who adduced evidence that the supply of hoes in northern Uganda began in the 2013-2014 financial year. The third respondent, the Attorney General, argued that he was wrongfully joined in the petition as a party and asked court to strike him out.
We are of the view that in future, the law should be amended to make the Attorney General a respondent where there are allegations against government and its officials to participate as a party.
The Supreme Court justices also pronounced themselves on other issues, including on the allegation of unlawful electronic transmission of results from districts to the National Telecenter. There's no law that expressly prohibits the Electoral Commission from using the electronic transmission of documents. This is not non-compliance as argued by the petitioner. On counting and tallying of votes in absence of petitioner's agents, the justices said our analysis of the evidence presented shows that at most polling stations, vote counting was done openly and transparently. There's also evidence that the petitioner did not have agents at all polling stations. Failure to accord equal treatment or coverage to all presidential candidates by government media outlets. The ruling was that it's true that Uganda Broadcasting Corporation failed to provide equal coverage to all the presidential candidates as required by the Constitution. Although the candidates may not have asked for it, it was incumbent upon UBC to show that it did offer the time. But this is a matter of legal reform. On the allegation of multiple voting, the justices said we find no evidence of multiple voting. The allegations could not be verified, given the nature of the evidence adduced by the petitioner. So today seems to be the end of the legal road for the petitioner, Amama Mbabazi, in challenging President Yoweri Museveni's re-election, saying that the court is the first and last court that can hear a presidential election petition, and so they have no chance to appeal this decision. We now await the swearing-in ceremony of President Yoweri Museveni which will be in May. Shiran Huchre, NTV at the Supreme Court in Kampala.